Imagine you or your partner is pregnant. You're expecting soon and are excited to have a baby. The prospect of parenthood is exhilarating, and you and your partner eagerly await the newest addition to your family. Now remember that children in the womb are not recognised in Australian law. Your baby is not legally protected from harm, and no help is available should such a circumstance arise. As a mother or father, your love and care can only reach so far. How would it feel to know that you cannot fully protect your baby because it is not acknowledged in existing law? Family law holds the welfare of children of paramount importance. The rights of children are frequently a topic of parliamentary debate, being evaluated and re-evaluated with the child's best interests always in mind. It may be surprising to know that the passionate protection of children's rights only extend to a child once they are capable of living outside the womb. Simply put, a developing fetus has no recognition under Australian family law. Most alarmingly, an unborn child is not protected from harm. Prenatal injuries, being those that occur inside the womb, are not acknowledged in existing legislation. Therefore, unborn children are not protected or compensated from harm they may suffer as a result of injury inflicted during pregnancy. Prenatal injuries are a leading cause of infant mortality and poor health and well-being. Specifically, the ingestion of harmful substances, such as alcohol, drugs, and tobacco, and unforeseeable circumstances, such as car accidents, are the leading contributors to this information. According to the Australian Bureau of Statistics, 1 in 7 pregnant women smoked tobacco and 51% drank alcohol in 2009 and 10 respectively. The Australian Institute of Health and Welfare has released that maternal drug, alcohol and tobacco ingestion causes low birth weight, preterm birth, placental complications, slower fetal brain development, fetal alcohol syndrome, development disorders, and of course, death. Circumstances where a pregnant woman and or her child are assaulted, abused, or suffer domestic violence have similar impacts on the child's health and well-being. Some cases even result in the death of the child, being stillborn or dying during delivery. This highlights the need for an amendment to current laws in regard to the rights of unborn children. It can be argued that the law as it stands leaves the choice to drink and smoke during pregnancy up to one's free will. However, the law also holds the right to life, particularly that of a child, at the height of importance. The ingestion of harmful substances knowingly causes damaging effects on the health and well-being of a child, and immediately withdraws this right. Despite this, no legislation exists in relation to this issue. As yet, the Family Law Act 1975 protects children from harm and violence. It has been amended several times to extend its operation to all children. Disturbingly, the law still does not recognise the rights of an unborn child. Also, Queensland's Child Protection Act 1999 defines harm as any detrimental effect of a significant nature on the child's physical, psychological, or emotional well-being. In itself, this is an effective explanation, but simply needs to extend to include detrimental effects that are inflicted during pregnancy. It is recommended that an amendment is made to the Commonwealth Family Law Act to protect the rights of children in utero. Currently, the rights of a child are only recognised when the child is capable of surviving outside the womb. Rather, the fetus itself should have legally protected rights, especially against harm. It is advised that the explanation of harm in Queensland's Child Protection Act be redefined to recognise prenatal injury imposed on a fetus. In particular, harm inflicted as a result of the ingestion of harmful substances, abuse, assault, or domestic violence must be outlawed. This should incorporate substantial consequences that are publicly known and enforced to deter potential offenders. To accompany this, compensation must become available to children who suffer harm caused by prenatal injuries. It is suggested that this compensation exists in the form of medical and financial recompense. This compensation should be for the benefit of the child, even in situations where parents themselves have caused the injury. Assistance available should be directly in relation to the harm suffered. It is noted that determining compensation should be informed by a medical expert. It is explicitly clear that a hole appears in Australian legislation where the rights of unborn children should exist. Particularly, the protection from harm and injury in the womb must be addressed in current laws. Harm that arises while the offender is aware of the adverse effects on the child, such as maternal drug ingestion, abuse, assault, and domestic violence, must be outlawed. Consequences must be publicly recognised and significant to deter potential offenders. Along with this, medical and financial compensation must become available to children suffering prenatal injuries. With these changes enacted in Australian family law, The void in legislation will be filled and unborn children will be protected from harm.